What we're talking about tonight is is a proposed amendment to our existing zoning ordinance to address gas drilling issues. What we plan to do is to introduce the amendment that Jason and Malin have been working on, along with, I might add, the attorneys for the town of Ithaca and the attorney for the town of Ulysses. If we introduce that tonight, we'll schedule a public hearing at least 30 days from now, because it has to be reviewed by the county planning board. And actually adjacent towns, I believe, also, right?
No, Chester.
Yeah. So we'll schedule a public hearing for 30 days from now. I think that's the point. So I would yield the floor to Attorney Perkins.
I have some brief remarks before I give you this latest version of the proposed amendment. Hillary, I was born in the old Ithaca Hospital too. I've lived here all my life too. So.
Oh, Steve Seller too.
What I'm going to hand you is a proposed amendment to the Town of Dryden zoning ordinance. It's based on the provisions of our ordinance that if an activity or use is not specifically permitted, it's prohibited. To this end, it clarifies that the definition in the ordinance of mining refers only to sand and gravel mining and not to gas and petroleum mining. To further clarify, it adds provisions clarifying that the exploration and extraction for natural gas and petroleum and other activities as defined in the ordinance is not permitted in any zone. I want to talk a minute about a preemption argument. And the Environmental Conservation Law, Article 23, Mineral Resources, Title 3, provides the provisions of this Article 23 shall supersede all local laws or ordinances relating to the regulation of the oil, gas, and solution mining industries, but shall not supersede local government jurisdiction over local roads. And this is the big issue. This is the elephant in the room. If it turns out that the state law does in fact supersede what you are planning to do, well, that's the end of it. I will note that there are two bills pending in the legislature, Senate Bill 3472 and Assembly Bill 3245, which would amend that language to make it conform to the language that appears with respect to sand and gravel mines, which would specifically allow towns to say where they could be located. Those bills are sitting, unfortunately, in the Committee for Environmental Conservation. So who knows what will happen to them. But clearly, if the legislature were to act and to approve those, that would put an end to the preemption issue.
Wait, I'm sorry, would you clarify that those two bills are in regard to?
Dave, I'll read you the purpose of the bill. To clarify the role of municipalities in governing oil, gas, and solution mining development within their jurisdiction. It would give you the same powers you have over sand and gravel mines, and that is you could say which districts they are in or not allow them at all.
Yeah, I mean, basically we're the same right now. The laws in the state that the mining reclamation law was in prior to Fruit Run.
Correct.
Great.
Fruit Run case as well.
We'll get to Fruit Run in just a minute.
Excuse me, Malin, could you read the bill numbers again?
It's Senate 3472 and Assembly 3245.
Maybe we can get something up on the web.
So write, if you are interested in this topic, write to or email your legislators. The activities and uses in this proposed amendment are addressed as land uses, and the impact of such uses of land on the health, safety, and welfare of everyone in the town. Authority. I think it's pretty clear the town has authority to enact zoning for this purpose. The town board and I are in the process of preparing an extensive resolution to be considered at the time you vote on this law, which clearly outlines the nexus with land use. And that's right now about 10 pages long, as you're aware. This is a regulation of land use under the zoning powers of the town. Town Law 261 provides for the purpose of promoting health, safety, morals, or the general welfare of the community, the board is hereby empowered by local law or ordinance to regulate and restrict, and it continues, the location and uses of buildings, structures, and land for trade, industry, residence, or other purposes. Town Law Section 262 provides the town board may divide the town into districts of such number, shape, and area as may be deemed best suited to carry out the purposes of this act, and within such districts it may regulate and restrict the erection, construction, reconstruction, alteration, or use of buildings, structures, or land. Those are your zoning powers. In addition, the Municipal Home Rule Law gives you the authority by local law to enact local laws for the protection and enhancement of its physical and visual environment, the government, protection, order, conduct, safety, health, and well-being of persons and property therein, the town. This provision shall not be limited to the power to adopt local laws, shall include but not be limited to the power to adopt local laws providing for the regulation or licensing of occupations or businesses. I think there's plenty of authority. In terms of due process, unless you are dealing with a use in a protected class where a heightened or strict scrutiny is required, the standard that you must meet is only that the regulation must be rationally related to the legitimate governmental interest. There is a strong presumption of constitutionality of local land use regulations. Those attacking them have a very heavy burden to show that they are not constitutional. Businesses or industries that you are talking about clarifying that are prohibited by this amendment are not in a protected class. The findings in the resolution, the draft resolution you have, outline and elaborate on the legitimate governmental interests served by the proposed amendment. The protection of the health, safety, and welfare of residents of the town. And in such, this law is not the regulation of a business, but a regulation of land use. And the resolution, I believe, shows clearly that it's related to land use impacts. You've heard much about cases called Fru Run and Granat. And the people that brought those cases have followed a similar approach. And I want to read to you, if you bear with me, just some of the language in the Granat Asphalt versus Town of Sardinia decision. And the first part of it, this is a Court of Appeals case in 1996. The court is talking about the Fru Run case, which it had decided earlier. In Fru Run, we distinguished between zoning ordinances and local ordinances that directly regulate mining activities. Zoning ordinances, we noted, have the purpose of regulating land use generally, notwithstanding the incidental effect of local land use laws upon the extractive mining industry. That's what Granat was about. Zoning ordinances are not the type of regulatory provisions the legislature foresaw as preempted by the Mine Land Reclamation Law. And we're drawing an analogy here. The distinction is between ordinances that regulate property uses and ordinances that regulate mining activity. I think that's an important distinction to keep in mind. We do not want to go near regulating mining activities. In concluding, in talking about that, the court said we conclude that the mine land reclamation law does not preempt the town's authority to determine that mining should not be a permitted use of land within the town and to enact amendments to the local zoning ordinance in accordance with that determination. In other words, the town of Sardinia excluded all mining. Talking about the exclusionary zoning, the court went on to say, we have never held, however, that the Berenson test, which refers to another court of appeals, which is intended to permit a municipality from improperly using the zoning power to keep people out, also applies to prevent the exclusion of industrial uses. A municipality is not obligated to permit the exploitation of any and all natural resources within the town as a permitted use if limiting that use is a reasonable exercise of its police powers to prevent damage to the rights of others and to promote the interests of the community as a whole. That's the Court of Appeals. Now there are clearly many different possible approaches to this issue. One approach you've heard a lot about is to define high-impact industrial use and draft the ordinance in such a way that it encompasses the activities outlined in what we've presented. This approach, unfortunately, involves a much broader issue. How to define that use and examining all possible uses and scenarios that could be covered by that definition. There's a substantial risk of a provision being overly broad. To avoid this, there needs to be a very careful study of all possible scenarios which would fall under such a definition. This is difficult, if not impossible, to do in a short period of time that we are talking about. I believe there's also a risk of being under-inclusive. And by that I mean banning land use effects in some circumstances, but not others. For example, effects are banned if they are by a high-impact industrial user, but not by a commercial or an agricultural. And if the town bans only one, but not all methods of gas drilling, it is risky because it amounts to regulating the industry. That is, how the drilling can be done. If there is a new high-impact industrial law, it does not provide a strong an argument against a potential use variance application and takings claim. On the other hand, if the activity which we're clarifying has always been prohibited, entering into oil and gas leases results in a self-created difficulty, which makes it impossible to get a use variance. The zoning ordinance does not currently allow high-impact industrial uses. Well, it could, as part of reworking the ordinance, local land use regulations which do not relate to the regulation of the oil, gas, and solution mining industries. And I want to just talk briefly about how this is different from the one that you've had before you. We have expanded the definitions a little bit more to include petroleum exploration, and we have added a new definition of natural gas and/or petroleum support activities. And that shall mean the construction, use, or maintenance of a storage or staging yard, a water or fluid injection station, a water or fluid gathering station, a natural gas or petroleum storage facility, or a natural gas or petroleum gathering line, venting station, or compressor associated with the exploration or extraction of natural gas or petroleum. And then we have added as a prohibited use no land in the town shall be used for natural gas and/or petroleum support activities. So that's the major difference between what you saw as a draft earlier and what we are giving you tonight. This will be subject to seeker, and it will be subject to review by the county planning department. So you have to plan your public hearing for